Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. In other videos on this channel, we discuss certain types of visas that can only be classified as investor visas. Things like the EB-5, which allow for direct investment in the U.S. economy and have the added benefit of allowing for a long-term green card status in the United States, permanent residence. Other visas, such as the E-2, allow for one to travel to the United States and remain there for the purpose of maintaining a business. The E-2 does not provide quite the same rights that the EB-5 does, especially with respect to lawful permanent residence, but it does allow an individual or individuals to remain in the United States long-term with work authorization for the specific project upon which they're working. In either case, and in many of the cases involving investment visas to the United States, one of the biggest issues is going to be proving source of funds that are being used for investment purposes. So let's go ahead and just sort of talk through investment visas sort of generally and not in particular detail. One has to have a business plan. They have to have a reason, an investment vehicle, some reason that they're investing in the United States. In the E-2, it's usually a small business. With respect to the EB-5, it could be all number of things for all number of amounts of money as far as the underlying investment. Leaving those issues aside with respect to the underlying reason for investing, proof of source of funds is sort of an issue unto itself. And proving source of funds, what we're basically talking about here is the United States government has a mandate, especially the Department of State as well as the Department of Homeland Security, in ascertaining where the funds being used to invest came from and doing their due diligence to make certain that they didn't come from an illicit or illegal source. So for this reason, actually one of the most important aspects of investment visas to the United States is source of funds. I've dealt with cases of varying degrees of difficulty from this aspect of the case, mostly because, especially here in Thailand, the Thai economy is much more of a cash-based economy, certainly more so than the United States, but more so than many jurisdictions around the world. Thailand is very, very cash-based, and for that reason, sometimes proving up source of funds can be rather difficult. In some cases, it can be rather straightforward, depending on where the cash came from, but there are certain circumstances where it may just simply be impossible to prove source of funds. For this reason, it's very advisable to go ahead and hire an attorney, a legal professional, to be able to explain these issues up front. And if nothing else, it might not be a terrible idea if one is really serious about investing in the United States to go ahead and have an attorney do some due diligence to make certain that it looks reasonably feasible to prove source of funds prior to making the investment in the U.S., because it would certainly be a disappointing thing to see one's funds moved to the United States, invested therein, and then later a visa is not approvable because, again, proving the underlying source of funds isn't possible. And it may not necessarily be that these funds came from anywhere, again, illicit or illegal. It may simply be a situation where it's simply not possible to prove where, in fact, they came from at all. Again, it could have come from a perfectly legitimate source. It's just not a source one can prove. So for this reason, although it doesn't seem like it to most folks at the outset of looking into a case like looking into a visa like an E-2 or an EB-5, believe me when I say proving source of funds can be one of the major obstacles ultimately in visa approval.